This is the Sale of Goods Act of 1979, Chapter 54, Part 2, Foundation of the Contract, Contract of Sale. Number 2, Contract of Sale. A contract of sale of goods is a contract by which the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. 2. There may be a contract of sale between one part owner and another. 3. A contract of sale may be absolute or conditional. 4. Where under a contract of sale the property in the goods is transferred from the seller to the buyer, the contract is called a sale. Where under a contract of sale the transfer of the property in the goods is to take place at a future time or subject to some condition later to be fulfilled, the contract is called an agreement to sell. Where under a number 5, I'm gonna read again. Where under a contract of sale, the transfer of the property in the goods is to take place at a future time or subject to some condition later to be fulfilled, the contract is called an agreement to sell. An agreement to sell becomes a sale when the time elapsed or the conditions are fulfilled subject to which the property in the goods is to be transferred. Number 3, capacity to buy and sell. Number 1, capacity to buy and sell is regulated by the general law concerning capacity to contract and to transfer and acquire property, where necessaries are sold and delivered to a minor or to a person whom by reason of mental incapacity or drunkenness is incompetent to contract, he may pay a reasonable price for them. Number 3, in subsection 2 above, the necessaries mean goods suitable to the condition in life of the minor or other person concerned and to his actual requirements at the time of the sale or delivery. Formalities of contract. Number 4, formalities of contract. Number 4, how contract of sale is made. Subject to this and any other act, a contract of sale may be made in writing, either with or without seal, or by word of mouth, or partly in writing and partly by word of mouth, or may be implied from the conduct of the parties. Number 2, nothing in this section affects the law relating to corporations. uh, this is subject matter of contract. Number 5, existing or future goods. Number 1, the goods which form the subject of a contract of sale may be either existing goods owned or possessed by the seller, or goods to the manufactured or acquired by him after the making of the contract of sale in this act, called future goods. Number 2, there may be a contract for the sale of goods, the acquisition of which by the seller depends on the contingency which may or may not happen. Number 3, whereby a contract of sale the seller purports to affect a present sale of future goods, the contract operates as an agreement to sell the goods. Number 6, goods which have perished. Where there is a contract for the sale of specific goods and the goods without the knowledge of the seller have perished at the time when the contract is made, the contract is void. Where there is a contract for the sale of specific goods and the goods without the knowledge of the seller have perished at the time when the contract is made, the contract is void. Number 7, goods perishing before sale, but after agreement to sell. Goods perishing before sale, but after agreement to sell. Where there is an agreement to sell specific goods and subsequently the goods without any fault on the part of the seller or buyer perish before the risk passes to the buyer, the agreement is avoided. Where there is an agreement to sell specific goods and subsequently the goods without any fault on the part of the seller or buyer perish before the risk passes to the buyer, the agreement is avoided. The price. Ascertainment of price. Number 8, ascertainment of price. Number 1, the price in the contract of sale may be fixed by the contract or may be left to be fixed in a manner agreed by the contract or may be determined by the course of dealing between the parties. I'm going to read that one again. The price in a contract of sale may be fixed by the contract or may be left to be fixed in the manner agreed by the contract or may be determined by the course of dealing between the parties, negotiating really. Number 2, where the price is not determined as mentioned in subsection 1 above, the buyer must pay a reasonable price. You got to look up what reasonable price is. Number 3, what is a reasonable price in a question of fact dependent on the circumstances of each particular case? Number 9, agreement. Number 9, agreement to sell valuation. Number 1, where there is an agreement to sell goods on the terms that the price is to be fixed by the valuation of a third party and he cannot or does not make the valuation, the agreement is avoided, but the goods or any part of them have been delivered to and appropriated by the buyer, he must pay a reasonable price for them. Number 2, where the third party is prevented from making the valuation by the fault of the seller or buyer, the party not at fault may maintain an action for damages against the party at fault. Okay, number 3, I can't really see what number 3 says. So it look like I didn't went too far. Oh, it's not number 3, it's number 10. I can't see. But underneath is 1. Damn, I just seen it. Doggone it. Uh, damn. I could see it, then it go away. Stipulation, stipulation about time. Stipulation about time. Unless a different intention appears from the terms of the contract, stipulation as to time of payment of the stipulation as to time of payment are not of the essence of the contract of sale. Unless, I'm going to read that one again. One, unless a different intention appears from the terms of the contract, stipulations as to time of payment are not of the essence of a contract of sale. Uh, Two, whether any other stipulation as to time is or is not of the essence of the contract depends on the terms of the contract. Three, in a contract of sale, month prima facie means calendar month. In a contract of sale, month prima facie means calendar month. Number 11, when conditioned to be treated as warranty. They don't even have a one on this one. So it goes straight to number 2. Where a contract of sale is subject to a condition to be fulfilled by the seller, the buyer may waive the condition or may elect to treat the breach of the condition as a breach of warranty and not as a ground for treating the contract as reputable, repudiated. The contract is repudiated. Number 3, whether a stipulation in a contract of sale is a condition, the breach of which may give rise to a right to treat the contract as repudiated, or a warranty, the breach of which may give rise to a claim or damages, but not to a right to reject the goods and treat the contract as repudiated, depends on each case on the construction of the contract, and a stipulation may be a condition through though called a warranty in the contract. I'm going to read that one again. Number 3, whether a stipulation in a contract of sale is a condition, the breach of which may give rise to a right to treat the contract as repudiated, or a warranty, the breach of which may give rise to a claim for damages, but not to a right to reject the goods and treat the contract as repudiated, depends in each case on the construction of the contract, and a stipulation may be a condition, though called a warranty in the contract. Number 4, damn, this one skip all kind. They don't have a number 1 or number 5. Number 4, subject to section 35A below, where a contract of sale is not severable and the buyer has accepted the goods or part of them, the breach of a condition to be fulfilled by the seller can only be treated as a breach of warranty and not as a ground for rejecting the goods and treating the contract as repudiated, unless there is an express or implied term of the contract to that effect. Number 6, nothing in this section affects a condition or warranty whose fulfillment is excused by law by reason of impossibility or otherwise. Number 12, implied terms about title, etc. Number one, in a contract of sale other than one to which subsection 3 below applies, there is an implied term on the part of the seller that in the case of a sale he has the right to sell the goods, and in the case of an agreement to sell he will have such a right at the time when the property is to pass. Implied terms about title, etc. In a contract of sale other than one to which subsection 3 below applies, there is an implied term on the part of the seller that in the case of a sale he has a right to sell the goods, and in the case of an agreement to sell he will have such a right at the time when the property is to pass. Number 2, in a contract of sale other than one to which subsection 3 below applies, there is also an implied term that A, the goods are free and will maintain and the goods are free and will remain free until the time when the property is to pass from any charge or encumbrance not disclosed or unknown or known to the buyer before the contract is made, and B, the buyer will enjoy quiet possession of the goods except so far as it may be disturbed by the owner or other person entitled to the benefit of any charge or encumbrance so disclosed or known. Let me see if I can see this one. Number 3. This section applies to a contract of sale in the case which there appears from and I don't see nothing else there. Damn. Number 3, so I missed number 3. Number 4, in a contract to which subsection 3 above applies, there is an implied term that all charges or encumbrances known to the seller and not known to the buyer have been disclosed to the buyer before the contract is made. Number 5. In a contract to which subsection 3 above applies, there is also an implied term that none of the following will disturb the buyer's quiet possession of the good, namely, A, the seller, B, in a case where the parties to the contract intend that the seller should transfer only such title as a third person may have that person. C, anyone claiming through or under the seller or that third party otherwise than under the charge or encumbrance disclosed or known to the buyer before the contract is made. 5A. The term implied by subsection 1 above is a condition, and the terms implied by subsection 2, 4, and 5 above are warranties. 13. Sale by description. Number 1. Where there is a contract for the sale of goods by description, there is an implied term that the goods will correspond with the description. 1A. The term implied by subsection 1 above is a condition. Number 2. If the sale is by sample as well as by description, it is not sufficient that the bulk of the goods corresponds with the sample of the goods do not also correspond with the description. Number 2, if the sale is by sample as well as by description, it is not sufficient that the bulk of the goods correspond with the sample if the goods do not also correspond with the description. Number 3, a sale of goods is not prevented from being a sale by description by reason only that being exposed for sale or hire, they are selected by the buyer. 14. Implied terms about quality and fitness. Number 1. Except as provided by this section and section 15 below, and subject to any other enactment, there is no implied term about the quality or fitness for any particular purpose of goods supplied under a contract of sale. Where the seller sells goods in the course of a business, there is an implied term that the goods supplied under the contract are of satisfactory quality. 2A is for the purpose of this act, goods are of satisfactory quality if they meet the standard that a reasonable person would regard as satisfactory, taking account of any description of the goods, the price, if relevant, and all the other relevant circumstances. 2B, for the purpose of this act, the quality of goods includes their state and condition, and the following, among others, are inappropriate cases, aspects of the quality of goods. All right. 2B has A underneath it. Fitness for all the purposes for which goods of the kind in question are commonly supplied. B. No. B. Appearance and finish. C. Freedom from minor defects. D. Safety, and E. Durability. And durability. 2C. The term implied by subsection 2 above does not extend to any manner making the quality of goods unsatisfactory. Underneath A, which is specifically drawn to the buyer's attention before the contract is made. B, where the buyer examines the goods before the contract is made, which that examination ought to reveal, or C, in the case of a contract for sale by sample, which would have been apparent on a reasonable examination of the sample. 2D, if the buyer deals as consumer, if the buyer deals as consumer, the relevant circumstances mentioned in subsection 2A above include any public statements on the specific characteristics of the goods made about them by the seller, the producer, or his representative, particularly in advertising or on labeling. 2E, a public statement is not by virtue of subsection 2D above a relevant circumstance for the purpose of subsection A above in the case of a contract of sale if the seller shows that A, at the time the contract was made, he was not and could not reasonably have been aware of the statement. B, before the contract was made, the statement had been withdrawn in public, or to the extent that it contained anything which was incorrect or misleading, it had been corrected in public. Or C, the decision to buy the goods could not have been influenced by the statement. 2F, subsection 2D and 2E above do not prevent any public statement from being a relevant circumstance for the purpose of subsection 2A above, whether or not the buyer deals as consumer. If the statement would have been such a circumstance apart from this subsection, from those subsections. Number 3, where the seller sells goods in the course of a business and the buyer expressly or by implication makes known A, to a seller, or B, where the purchase price or part of it is payable by installments, or the goods were previously sold by the credit broker to the seller to the credit broker. Let me see if I can see this one. Could look like it's cutting some of it off, so I can't see that. Let me see where I was. So I read number 3B, and then it looked like it's going to 3B. It must got 3C. I can't really see it, so I'm gonna go here and I can't see it. The thing I can see is say the circumstances show that the buyer does not rely, or that it is unreasonable for him to rely on the skill or judgment of the seller or credit broker. Number 4, an implied term about the quality or fitness for a particular purpose may be annexed to a contract of sale by usage. Number 5, the preceding provisions of this section applies to a sale by a person who in the course of a business is acting as agent for another, as they apply to a sale by a principal in the course of a business, except where that other is not selling in the course of a business, and either the buyer knows the fact or reasonable steps are taken to bring it to the notice of the buyer before the contract is made. I'm going to read that one again, number 5. The The preceding provisions of this section applies to the sale by a person who in the course of a business is acting as agent for another, as they apply to a sale by a principal in the course of a business, except where that other is not selling in the course of a business, and either the buyer knows that fact or reasonable steps are taken to bring it to the notice of the buyer before the contract is made. 6. The terms implied by subsection 2 and 3 above are conditions. Sale by sample. Sale by sample. Number 15, sale by sample. 1. A contract of sale is a contract for sale by sample where there is an express or implied term to that effect in the contract. A contract of sale is a contract for sale by sample where there is an express or implied term to that effect in the contract. 2. In the case of a contract for sale by sample, there is an implied term. A, that the bulk will correspond with the sample in quality. C, there's no B on this one, just A and C, that the goods will be free from any defect, making their quality unsatisfactory, which would not be apparent on reasonable examination of the sample. 3. The term implied by subsection 2 above is a condition. Miscellaneous. 15A. Modification of remedies for breach of condition or non-consumer cases. 1. Where in the case of a contract of sale A, the buyer would, apart from this subsection, have the right to reject goods by reason of a breach on the part of the seller of a term implied by section 13, 14, or 15 above. But B, the breach is so slight that it would be unreasonable for him to reject them. Then, if the buyer does not deal as consumer, the breach is not to be treated as a breach of condition, but may be treated as a breach of warranty. 2. This section applies unless a contrary intention appears in or is to be implied from the contract. It is for 3. It is for the seller to show that a breach fell within subsection 1B above. This is whenever we come back, we're going to get to part 3, effects of the contract.